Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to the second part regarding the clauses that we are going to put in an Islamic will when we draft a will. We have the previous one we have discussed. Just to recap, you must put your revocation clause, you must put your identity clause, your revocation clause regarding your body, your burial, your kafan dafan, your debt and your bequest. What I want to expand now is further about other clauses that you can consider. As usual, remember this is an awareness program. You got to consult the professionals. I don't carry any liability if you misinterpret what is being said. Ensure that you consult the professional. So what we're going to do here now, the next one, I want to add the fifth thing that you can put in your will would be your inheritance. Now, as you know, in Sharia, there are specific rules who receives what. There are three types of heirs under Sharia. One is what you call the Quranic heirs. These are people who will inherit in any case, except where there are what you call the mawani ul irth, impending circumstances, like there's a murder or there is a difference of religion, etc. That is a separate issue. They will not inherit. Now, these are the Quranic heirs. Their shares are specified in the Quran, should they inherit. This is why I put the condition, should they inherit. Or their status must change. For example, the case of a daughter, she will inherit 1/3. If there are more than one daughter, it becomes 2/3. But if there is one son even, they will change the status. They become the second category, which is known as a residuary. The residuary are those who will receive whatever is left over after we have given the Quranic heirs, like your wife, the husband, or the mother, or the father. These are Quranic heirs. Their shares are stipulated. So when you give them whatever their shares, whatever is left over, go to the residuary. Then there is a third category. Should there be no residuary and the father is not here, you will have to give a share to the uterine relationship. That is, those who are from the same mother. Okay? So there are three levels of heirs, and this is very intricate, very advanced in Islamic law of inheritance. So when you decide to write your will, you have two ways of doing that. This specific clause. One is you specify their share as mentioned, and the second one, people will do what you call, they put it a letter of intention, where they will shift it to, or letter of wishes, where they appoint a trustee and they direct the trustee to distribute it according to Sharia. So everything goes to the trustee, somebody whom you trust, and the trustee will take over. So of course you got to send it to the probate officer. One thing I want to draw your attention, any will in the world, any will can be challenged. So keep this in mind, make sure you draft that clause properly, and you want to say who will receive what after your estate is devolved. Like in some jurisdiction, we don't put the name there. What we say, we wish our estate to be devolved to our legal heirs according to Sharia, and for that we issue such mufti or such Islamic organization to submit a calculation who receives what. And that calculation or that certificate is submitted with the will to the court. So this is other jurisdictions that you can do. I have not so far seen any case law on that specific issue in England. I have seen it in countries like South Africa, which is very well established with this specific area of your inheritance clause. So this is an area that, again, your lawyers will tell you. So another important point which needs to be debated regarding inheritance. I'm raising it though because there are differences of opinion among the fuqaha, and it is a genuine problem, and many elderly people come to me regarding it. There is a concept in the Maliki School called Omrah. That is, you transfer the house, for example, to your children, but the right to stay in the house remains to your spouse because she's very old, for example. In the Hanafi fiqh, what I've understood from the ulama, this is not permissible. But in other countries, like in Singapore, for example, they have this there. So again, it is a genuine problem where you have only one house and you worry for your wife, for example, because she's going to get 1/8. 1/8 is not adequate. Can you let her stay in your house? At times, children can be not in their best of moods to look after their mother. So these are precautions we take. We are to be blamed if our children misbehave this way because we haven't brought them up properly, right? So reality, this is a problem. I've dealt with many cases like this in practice where people don't know what to do with that specific area of law regarding the right to enjoy the house, though the house is not in your name. After this important point about your drafting your inheritance clause, the next one is protection of minors. Again, from a Sharia point of view, this is important to take into account. Because who becomes the guardian of the child, from a Sharia point of view, this is more or less determined. It is tried to be the matriarchal line. There are two stages here. One is the haqqul rada'a, where the child stays with the mother, usually up to say 7 years old, where the child is become independent, and then usually the father can take over the child. This is what we read in the book of fiqh. And who has the right over the child? Very important. Under UK law and many other jurisdictions, the law says that if there is a dispute on that, the judge of the High Court is the upper guardian of the child. And the judge will look at the best interest of the child. And this is more or less in line according to my reading with the Maliki School. So that is another issue. There are criteria that the court will look at the level of education, affection, etc. of the child. And the best interest of the child is the focus under English law and other jurisdiction, which is a bit different from what we have in Sharia, for example, to get the concept of khairul abawain, the best of the parent, etc., etc. So these are important issues to consider to protect your child. Not only your child, but also if there's a dependent who is not your heirs, but dependent on you. For example, one of your auntie or your uncle, very elderly, you got a responsibility to look after. And maybe they cannot take decision, old age. So in that case, what I would advise you to do is to make a testamentary trust. That is in your will, you create a trust, their shares go in that trust, and you will appoint a trustee who will look after them. That is something you can consider into the issue of testamentary trust. And when the child is 18, of course, the child will be an adult, he will get whatever you have left for him. So this is important, right? So the testamentary trust is important because in some countries, what happens if you don't put this provision, the state will take that money, right? And as a trust, they will not invest it in a good investment. And the rate of return is very low. So after, say, 10, 15, 20 years, that money, the purchasing power behind that money is not much. And if it is a house, maybe they will sell the house and convert it to a money. So this is why a testamentary trust is something you must consider when you have minors and people who are dependent upon you. Another important issue, may Allah protect us, but we have heard it many times. You have a train crash, you have a plane crash, a car crash, when the entire family disappears and there is no heirs. What happens to your estate? If you don't make a provision for that, in some countries, the state will take over what's called the prescription. In some countries, you got the Prescription Act. Thereafter certain times, the state will, certain time lapse, they will take over. And nobody can claim it. So you must put what we call a residuary gift provision. What does this do? It helps you to declare that as a wasiyyah, and you can give it as a sadaqatul jariyyah to a charity organization, a darul ulum, or whatever you want, build a masjid or whatever. So that residuary gift will only apply if there is no heirs at all. Then only this residuary gift clause will apply. That is the main thing. Now, as we know, wherever there is money, often there is fight, and people tend to pay big legal fees for that, especially if there are thousands and millions of pounds involved. Definitely the lawyers, that's business, we got to understand. My advice to you is put an arbitration clause in your will. What is an arbitration clause? An arbitration is, this is under the Arbitration Act of 1996 in UK, and many other countries got Arbitration Act. You can arbitrate it. Not everything you can arbitrate, like custody of children, criminal matters, and things like changing your status, that you got to go through the court. But generally, anything can be arbitrated. What is arbitration? It is a quasi-judicial method. It is an alternative dispute resolution mechanism. So it is quasi-judicial. It's similar to the court, but it is not the court. But you appoint an arbitrator who will be similar to a judge. Similar. He's not a judge, of course. So when he make an award, not a judgment, that award is binding. Should somebody don't want to follow, then you take it to the court, you make it a court order, then it becomes the law. It becomes similar to a judgment. This is why you call it quasi-judicial. And this is regulated by the Arbitration Act. You can consult your lawyer to know more. So what the advantage of this is to prevent the children to fight unnecessarily, because by the end of the day, this is your will. It is your estate. You want to distribute it according to your faith. Under the freedom of testation concept in UK, you can give to whoever you wish, as long as you are not trespassing the right of somebody else. So you can give, people are giving the estate to dogs, to their dogs. People are doing that, okay? So you got to understand, on the freedom of testation, you have the right to distribute to whoever you want. Your children, if they are minors, they will be dependent on you. They are very poor, they will be dependent on you. But if they are working, then they might not claim whatever they want from you. You decide it. So under the freedom of testation, you are protected. Your right to distribute it is okay, as long as it is not against public policy, okay? So you are distributing it the way you want. You don't want people to waste millions of pounds in legal cases, fighting in courts, because there's nothing left. So you put an arbitration clause that the arbitrator will implement your wills according to your wishes, should there be a dispute. So this, I think, is very, very important. If you don't put that, what will happen? There will be delayed in distribution of your estate. Believe me, going to court, that can take 2 years up to 5 years. And those who really deserve to have it will not have their shares. So an arbitration is a quicker way to solve this problem. Again, you have to consult your lawyer to ensure you draft it properly. The next one is some malpractices. So these are basically the main things what you put in Islamic will. Some is, first is you got to follow the Wills Act of UK. Number 2, you got to have a quick wrap up. You got to have identification of yourself. Number 2, you must revoke your previous wills. Number 3, you must put a provision what to do with your burial, your shroud, your body. Number 4, appoint your administrators. Number 5, if you got any debt, sort out those debt, make provision, if there is a provision to be made for outstanding income tax or inheritance tax, etc. Then after that, you make your bequest. Who will get what from you besides your legal heirs, okay? Next, after that, you put your inheritance clause, or you can have your letter of wishes and you transfer it in a trust. Then, if you have minors, make sure you make provision for their guardianship and who will look after the estate. Then you have to have a residual gift. If there's no heirs whatsoever, you put a residual gift for somebody to get it. If not, you're going to lose everything. And this is a chance for you to get sawab jariyyah in the hereafter, sadaqatul jariyyah. Then of course you put an arbitration clause. After you finish all the things, don't forget to sign, to have your 2 witnesses, and to date it. I told you that. This is a wills act. Don't forget about it. Now, before I end this, some of the malpractices in our community I would like to highlight. The first thing is we confuse between donation and inheritance. You tell, for example, your child, one of your son or your daughter, this car is yours, but I'm driving it. Listen to it. I give you this car. Now, you haven't signed any paper to transfer it on his name. What proof other people will have that you have said this to him? And this is a common mistake we do. During our lifetime, we donate without ensuring that the ahkam of hiba, that is a law of donation under Sharia applies. Under the Hanafi fiqh, for example, if you donate things, there must be an acceptance and the people must take qabza. They must take possession of it as well. Then it is a complete donation. So there are very specific rules on donation in common law, whereas inheritance is different. Inheritance is already determined. Inheritance will only take place after your death. So nothing prevents you to donate during your lifetime. You donate it, but do it properly. Number 2, many a times we have a business and our son has helped us in our business and we assume that the son will get the business. That is wrong. If you want your son to be your partner in the business, this must be stipulated. Because we tend to neglect the daughters. That's not right. So there must be proper documentation. This is why the longest verse in the Quran is about documentation in Surah Baqarah, about loans and so on. So make sure we document those things properly. Verbally, your right hand cannot trust your left hand in today's time. Who you trust when it comes to money. So make sure there are proper documentation. Another important thing is matrimonial regime. Different countries have different ways of distributing estate to their wives. For example, you buy a house in England, you can have joint tenancy or tenancy in common. Each one got its own rulings. But under Sharia, we assume yours is yours, hers is hers. This is an area where we need to consult the ulama and the lawyers, because if you got a house worth 400,000, then you got the cars, etc. And everything is a name of the husband, for argument's sake. The wife will get only 1/8 from a Sharia point of view. And the wife has worked to pay all those mortgages, for example. So we have to be a bit realistic with those practical issues, and not after our death the family start fighting and wasting money in court unnecessarily. So matrimonial regime also we have to be careful. Importantly is lack of estate planning. Please plan our estate. Having a will is part and parcel of wealth management and estate planning. In my first lecture, which I've given to you already, I explained about it. I'm not going to repeat it. You must have estate tax planning as well, which I have alluded to earlier on. Undeclared money, offshore accounts, especially those in business. Make sure you got a responsibility vis-a-vis this. Often we don't make tax provisions in case of assessments. If you're in business, often you can have tax assessment, and this will be taken from the will. Another important thing I want to say, specifically for Muslims. When a husband dies, the wife will be in iddah. Make a financial provision for her. This is important that we mention this. We must make provision for the wife, because for 4 months plus minus she's going to stay at home. Okay, so make sure these malpractices we avoid that. So I hope these 3 lectures will give you a bird's eye view about the law of wills in UK, how we draft Islamic wills that fits within the Wills Act, and what are the provisions we put in, financial provisions. We don't want to go to Allah that we are liable, we have done so many wrong things. We don't want to die that when we are in our grave, our heirs are thinking bad about us, talking bad about us, and have bad schema about us. And finally, remember, ensuring, if you look at Surah An-Nisa, ensuring you do your will properly, and it comes in Bukhari as well, we must not spend 2 nights without it. This can be a source of salvation for us in the day of Qiyamah, on the day of Qiyamah. Believe me, there are ahadith on that, there are ayat of Quran on this, that if we ensure our estate is distributed according to Quran and Sunnah, we take the necessary precaution, this can be a source of Jannah for us, a simple paper that we have signed. So I hope this benefit us, all of us. Allah give us tawfiq to practice upon it. Don't forget to consult the professionals. Okay? Subhanallah bihamdihi, subhanakallahumma, nashhadu an la ilaha illa anta, nastaghfiruka wa natubu ilayk.